Okay, page 107, estate planning. Right here. Reasons to do estate planning. So when I talk about estate planning, what I'm referring to is putting together documents while you're alive and while you're mentally competent that will be in place so that when you die, your assets are distributed the way that you want them to be, that you minimize and reduce taxes, that you minimize hassles and headaches and going to court after you die, so make things easier for your family or whoever you want to inherit your property. Or the other part of estate planning is making sure that you have planned ahead of time so that if you get sick, maybe you develop dementia, or you're hit by a bus and you're in a coma, you've got documents in place so somebody else can take care of you. Or if you have other needs within your family, like a child perhaps that has special needs, that you have in place a trust or some other document to care for that child after you're gone, if they need lifetime care. So these are a number of different reasons that we do estate planning. So for you guys, first of all, on the final exam, this is 100%. I ask this every single time. What are up to 6 reasons that you do estate planning? And I ask this every time because this is something all of you will have to deal with, right? Page 107. So what are the 2 certainties in life? It's a joke, right? Death and taxes, right? Not necessarily in that order. Taxes, death, then more taxes. So this is something all of you will have to deal with. That's why I talk about it in this class. Also, it's a very important part of business planning, especially in a family-run business, to make sure that you have planned ahead of time on how to transition the business to the next generation, or if you're not going to have somebody take over from your family, how to transition on your own, either have the business sold or whatever as part of your estate. So this is a critical part of business, the end game, right? All right, now, for you guys, most of these I don't really get into too much in terms of multiple choice, true-false questions. The highlighted words I do want you to know, and I'll explain those here more in a minute. But again, be able to list out 6 reasons why you do estate planning and just have a general understanding of what they are. So let's start with number 1, estate taxes. Estate taxes are taxes that are levied on assets that are transferred after you die, primarily to the next generation. And the idea is that there will be a dollar threshold that if you're below that dollar amount, there's no tax. If you're above the dollar amount, the value of the assets above that dollar amount are subject to a tax. And that tax can be as high as, well, at the federal level, I want to say 48% is the upper rate. So at the federal level, the current rate is actually, it went up to 11.4 million this year. So at the current federal rate, it's 11.4 million. So a very high level. So anything below 11 million, no tax. You can transfer 11.4 million tax-free to the next generation. Above that amount will be subject to a percentage, and that will increase the higher it gets. Oregon is much lower. Oregon is only 1 million. So you may not be taxable at the federal level, but if you're above $1 million in Oregon, you're subject to an Oregon estate tax, which is roughly 10%, goes up to 16%. So anything below $1 million, no tax. Above $1 million, potentially subject to tax. Now, if you're a married couple, each spouse can shelter $1 million, so $2 million for spouses. At the federal level, $22.8 million. But you have to do planning to make sure that you have your assets set up correctly, primarily through a trust, so that each spouse can shelter that amount. Way beyond the scope of this class, but I'm not going to test you on these dollar amounts. Okay, don't worry about that. I just want you to be aware that this is something you need to think about. Now, it seems like a lot. Yeah, $1 million is a lot, but that includes everything: life insurance, Most parents I know have life insurance. Very common to have $1 million of life insurance now. Real estate, retirement accounts, Bitcoin, whatever. Anything that you own factors into that $1 million, and it can add up pretty quick. Part two is that includes assets that may not be necessarily liquid. In other words, real estate, farm and forestry, business assets. Like for example, I have a client that has a trucking company. Just the equipment alone, all the semi-trucks and everything else that they have, well over $1 million in trucks. Farms, real common to have farmland. Farmland's expensive. You have a lot of farmland, you're going to go over $1 million pretty quickly. Equipment, combines and tractors and all of that, very expensive. So you get above $1 million. Manufacturing, the equipment, easily get above $1 million quite quickly. And so this is a real problem with small business especially, where like with land, I have a saying, you may be dirt rich but cash poor, especially in a farming situation. You have farmland worth $3 million, but you've got $42 in the checking account. So it's something that you need to think about because there are ways to minimize that tax. Again, way beyond the scope of this class. All I want you to know, real basic, at some level, and this changes, there will be tax and there are ways to plan for that. All right, number two, intestate succession. So I want you to know this word intestate. I want you to know what it means. I have a test question where I basically will ask you what is the definition of that word. So, intestate. All right? Now, the word intestate means that when you die, you do not have in place a valid will. You died intestate, without a valid will. Testate is the opposite. So if you die testate, that means you do have a valid will. Testate, to have spoken, like testimony, testament. So the derivative there is that you have spoken in a testament means that you've spoken in a final manner, in a solemn and final manner, very important manner. Testimony or under oath is important statements. So, testate, intestate. Intestate, no will, right? Testate, you do have a will. Intestate, no will. Testate, you have a will. I've repeated it now, 5 times or 6 times? I will test you on that word. That's why I have it highlighted. I also want you to know what it means to have what we call intestate succession. So intestate succession means if you do not have a will, the law will say how your assets will be divided up after you die. It depends on what your family situation is. So the law of intestate succession is the law that will apply if you don't have a will, and will therefore distribute the assets in accordance with the law. So let me show you an example of what we're talking about. Page 109. 109. This is an example of, an intestacy statute. In other words, an intestate succession law. What happens if somebody dies and they do not have a valid will? In other words, they are intestate. So basically, like I said earlier, the law will divide your assets depending on your family situation. So we look at, okay, are you married? Do you have children? If you're not married, do you have surviving parents? If you're not married and you have no children, your parents are gone, do you have brothers and sisters, siblings? Do you have nieces and nephews? And we'll work our way through your family tree. That's kind of how it works. So just to give you an example, And I will tell you, Oregon law is a little bit different than this one, but this is a good example. So let's say I die and I'm married, and I have children, or issue of a deceased child, which would be grandchildren. So we say the word issue means children. I have 3 issues myself. I have 3 children. One of them's more of an issue than the other ones. We won't go into that. So, I'm married and I have children. In that case, the law would say if I don't have a will, 1/2 would go to my spouse and the other half to my children, or my grandchildren, depending if I have a deceased child. All right, well, that's okay, I suppose. But there might be problems with that I don't want that to occur. So for example, let's say that my current spouse is not the parent of my children. In fact, let's say, I see this all the time. My current spouse and my children are from a previous relationship and they can't stand each other. So now, I die, I don't have a will, and so now my house, perhaps, the way I have it titled, half of my share goes to my spouse and my other part goes to my children who hate my spouse, and now they co-own this house together. And my spouse wants to go sell it, but they won't sign off on the deed, or they won't pay the property taxes or their fair share of upkeep. It gets really messy really quick. So you've got to make sure that if you want your spouse, most people want their spouse to get everything, then you want to make sure that you put in place a will or other proper joint ownership, tenancy by the entirety, or something else. All right, well, let's just keep going. Let's say I'm married, I have no children, I have no issues, but I do have a surviving parent. In that case, 3/4 to my spouse and 1/4 to my surviving parent. So now, my wife would end up co-owning our house with my mother, her mother-in-law, right? You can tell how good that would go, right? Of course, they love each other, but you don't really necessarily want to own your house with your in-laws. So that may not be the best result. Down here, let's say I'm married, I have no parent and no children, then all of my estate would go to my spouse. Well, that's probably what I want to begin with, so I need to make sure that I have a will in place that says that, or a trust, or some other document, which we'll get to more in a minute. And then you can see on down the line. If I have children but no spouse, everything divided among my children, and then you keep on going until the very bottom there. Eventually, if you run out of family, everything goes to the state. It's called an S sheet, which I won't test you on. So again, you don't need to memorize all these percentages and fractions. I just want you to have this general understanding of what intestate succession means. And that is the law will dictate where your assets go if you don't have a will or other estate planning document, which we'll get more into in a minute. Now just so you know, for the real world, on page 110, I have put Oregon's actual law here. I won't test you on this. You don't really need to look at it if you don't want to. But this is Oregon's actual statute, ORS 112, Chapter 112, which deals with if you don't have a will. It's something I have to deal with quite often in my practice. And you can kind of work your way through. It's kind of interesting in Oregon. So if you die and you're married, if you have a surviving spouse and no issue, your spouse gets everything. But if you do have children, if those children are not from that marriage, then half goes to your spouse and half goes to your children. If they are from that marriage, then everything goes to the spouse. So it's kind of interesting how that may play out. All right. So back to page 107 very quickly, and we're going to move. So you don't want to be intestate because you want to make sure your assets go to where you want. Okay, so how do you not die intestate? What do you have to do? Make a will. Thank you. So the question then is, okay, what are the requirements to have a valid will so that you're not intestate when you die? So we need to talk about wills now. So page 111. This is an overview, which is not exactly how Oregon law is, which we'll talk more about in a minute. But basically, when we say a will, what we're talking about is a document that will specify how you want your assets divided after you die, and will specify who you want to be in charge of your affairs after you've died. We call that, in Oregon, a personal representative. Other states will call it an executor. But basically is a person that will be in charge of things after you die. So your will is going to accomplish two things. Number one, who do you want to be in charge? And number two, how do you want your stuff divided up after you're gone? Those are the basic two things that a will accomplish. So we have three basic terms that we use for wills, and I want you to know the difference between them. So I'm going to start at the bottom. And what we call a non-cupitive will. Non-cupitive will. This is an oral will. That is, it's not in writing. So it's a statement that's made verbally in front of witnesses where you say where you want your assets to go after you die. Sometimes we call this the foxhole will or the combat will, and it derives out of military code where soldier or sailor in combat would tell their sergeant or whatever in front of other witnesses, hey, if I die, I want my fruitcake collection to go to my brother. Something, right? So, and how do you remember that? You're never going to remember that weird name, non-cupitive. I don't expect you to. Here's how you can remember though. If you see the will that starts with the letter N, the non-cupitive, then a will. N, what comes after N in the alphabet? O, right? N-O, no, it's no good. Not valid. In Oregon, you have to have a written will or you don't have a will. Doesn't matter, verbal statements mean nothing. It must be a written will that complies with formality. So the non-cupitive will, oral. You know that much, you're good. Not valid. So that leads us to the next one, holographic. A holographic will may or may not be valid. It depends. But first of all, what is a holographic will? Holographic means handwritten, done by the person's own handwriting. So I literally sit down with a pen. It's like a letter, okay? I, John Hasbrook, hereby make this my last will and testament. I hereby give all of my fruitcake collection to my brother. I give all my fishing equipment to my sister. I give my goldfish to my friend Stan. And I give everything else to Western Oregon University for scholarship fund, right? So a handwritten will. So how do you remember that? Simple. Holographic, H, handwritten. Okay? Handwritten. Now, depending on where you're at in the United States or within the world, a holographic will that has been signed and says that it's intended to be your will may be valid. In Oregon, it won't be valid unless it also meets the requirements of a formal will, which we'll get to in a minute, which basically is witnessed when it's signed. Other places in other countries, if it's handwritten and signed by the person and it says it's intended to be their will, even if it's not witnessed, it will be valid. I actually had that happen once. Handwritten will was recognized in New Zealand. We recognize that, where we don't here in the United States, or at least in Oregon. So, therefore, let's get to the requirements for a formal will. So, number one, it has to be in writing. Now, typically that's typed up, word processor, and printed out, but it could be handwritten. Must be in writing. So that's the first element of a valid will. W, written. Must be in writing. No verbal wills. Handwritten or typed up, that's okay. Number two, when the person signs the will, two people must witness it at least. In Oregon, we have to have a minimum of two. That's one of which cannot be an heir. In other words, we call that disinterested. Or three. In Oregon, you only need two. And that's what our normal practice is to have two witnesses see the person sign the will And then the witnesses also have to sign a statement that they saw that person signed a will. At the time, they were mentally competent and were not suffering from what's called undue influence. And then the witnesses also have to have an affidavit that's notarized. So written, signed by the person, and witnessed, WSW, written, signed, witnessed. The person must intend for it to be their will, and we say that right in the document itself. I declare this to be my last will and testament. Must be signed in front of the witnesses, and they must be mentally competent. So I have another page where I've made this a little bit easier to read. Page 106. 100%er for the final. I ask this every single time as well. What are 4 of the requirements needed for a valid will? There are more than this, but what are 4 is what I want you to know. Must be written, typed up, or handwritten. Must be signed by the person. Must be witnessed by 2 or more people, one of which is not an heir. In other words, they're not going to be inheriting anything. It is my practice that both witnesses must be disinterested and not inheriting anything. That way we don't have a conflict of interest. Number 4, the person must have what's called testamentary capacity. In other words, mentally competent. In other words, they understand what they're doing, they understand the purpose of a will, they understand why they're signing it. Now, it doesn't necessarily mean that they're 100%. You know, this is really common. Somebody has cancer or a physical ailment of some type. They may not be physically all that great, or they may be at the beginning of dementia, at the beginning stages of Alzheimer's, where they still, they have some memory issues, but they still understand for the most part what's going on. They just may forget things sometimes. They may just forget some things sometimes. They may forget things sometimes. They may forget things every once in a while, right? My dad passed away from Alzheimer's. I saw that progression. When he was young, when it first started happening, started repeating things like that. But, for probably a year or so, he was very good. So, doesn't necessarily mean you're 100%, but you have to have the level of capacity to where you understand what you're signing. I'm signing a will, and the purpose of that. Now, nowadays, in my practice, if I have a question, I'll usually have the doctor give me a letter basically saying, they do have early stages, but they're still mentally competent to be able to sign legal documents. And that way there's proof of that if there's ever a question. Number 5, when they sign the document, it must be their intent that it will be their last will. We put that right in the document, and then also that will overturn or cancel any previous wills that they've made. So those are kind of the basic requirements. All right, question.
Quick question. For like a disinterest party, I mean,
Yeah.
Can that be anybody, or is it like a notary public, or?
Yeah, it could be anybody. Now, the notary, you'll have to have the witnesses after they've signed will sign an affidavit that has to be notarized. So the notary will have to notarize the witnesses' signatures.
Oh, okay.
Yeah. All right, so you guys, WSW, written, signed, witness, mentally competent, mental capacity. You can phrase that however you want. I'll accept it as a fine answer, okay? However you want to say, mentally competent or whatever. And that's your purpose, your intent, or your desire that it will be your will. 100%, right there, 4 easy points for you on the final question. This is on page 106. Okay, so if you don't have a will, what's the word? Intestate. Make sure you know that word. Intestate means you do not have a valid will. And then that law of the percent where that will divide up will come into play. All right, more reasons for estate planning. Number 3, guardianship. If you have children under the age of 18 that are minors, back to page 107. Or I should also say too, if you have children that have special needs, maybe autism or something where they don't really and will never understand, things or be able to take care of themselves for that reason, then you want to make sure that you have at least one person, like to have a number of people in order that you name as a guardian. A guardian is someone that has legal authority over a minor child or a person that has, that is incompetent as an adult. A judge is the person that will appoint the guardian after you apply to the court. And one of the problems with a guardianship is it is an adversarial process. It is potentially, it's basically a lawsuit. And the problem that can happen if parents don't name a guardian, then it's kind of up to the family to figure out who it should be, and they may not agree. And it can lead to family fights. So, I mean, worst case scenario is something like, you know, let's say the parents are in an aircraft and it crashes and they both die. So now you have the young kids, their parents have just been killed, and they haven't named a guardian. And so now you've got the family going into court saying, you know, maybe the mom's saying, well, the grandmother says I should be guardian, and the sibling, the brother of the other parent says, no, I should be guardian, and then the brother or sister of the other one says, no, they're both whacked out, I should be guardian. Now you have the family fighting with each other. I mean, literally within days of the parents being killed. It's horrible. So we'll usually put that into the person's will, who they want to be the guardian, and then we'd also set up a trust for the minor children so that they don't inherit a bunch of money when they're under the age of 18 or 25 or whatever age you specify. So it's very important that you do that, and then have alternates in case somebody can't or will not be a guardian. All right, number 4, I'm going to come back to that in a minute because that goes along with number 5, privacy of estate assets. So that brings us to number 5 because they go together. And this is one of the most important reasons to do estate planning on this page. In order to avoid probate. So I want you to know that word probate. Probate, the way the probate in this class, what I'm referring to, is going to court after someone dies. Going to court after somebody dies, and a judge will oversee the administration of the dead person's estate. So going to court after someone dies. Now in the real world, probate's a little bit larger than that. Probate is the part of the court that deals with incompetent people, handling their affairs if they're incompetent, name changes, depending on what state you're in. It can be other types of things like that. But in this class, when I refer to probate, after someone dies, going to court. Now, why do you want to avoid probate if you can? Avoid going to court. Same old reasons we've talked about before. It's expensive. It's time consuming. You've got to hire lawyers to do everything unless you know what you're doing exactly. There are a lot of very technical procedures that have to be followed, notices that have to be published in the newspaper, court filing fees, minimum time periods. In Oregon, a minimum of 4 months for creditors to file claims. And then we have objection time frames, and it can be very time consuming and expensive. In addition, it's a public proceeding. So if there are privacy issues about what assets you have, you don't really want the world to know. You don't want people to know what your kids are going to be inheriting or something like that. Then you want to try to avoid probate from a public record standpoint. It's just one reason. Plus, again, it can be an adversarial process. It can lead to family fights and everything else. All right, so what does probate mean? Going to court after someone dies. That's actually one of my test questions. What does probate mean? And it's a multiple choice type question. That's the basic answer. Going to court after someone dies. All right. So now the question is, how do you avoid probate? Next page. 100%er, once again. What are 4 ways to avoid probate? Yeah?
Just curious if you passed the attendance sheet around or not yet.
Yes, I did.
No.
You can get it at the end. Just get it at the end. Yeah.
Cool.
Okay.
Thank you.
All right, 4 ways to avoid probate. It used to be 90%, I'm now putting it at 100%, all right? Which I pretty much asked it. Very important page. Again, something all of you guys will need to deal with at some point. And this page alone literally could save you thousands of dollars in costs and attorney fees. So, here's the basic idea, how to avoid probate. How to avoid going to a judge after someone dies. So the basic concept is somebody dies, there's an asset in their name. How do we get ownership of that asset out of the dead person's name into the name of a living person? Now, one way is through a will and going to court and having a judge order that through the probate process. But we don't want to do that, as I've already talked about. So what are other ways that we can transfer ownership without going to court? That's the basic concept. Well, number one, we've already talked about. That is owning an asset with another person as a joint owner with survivorship. So that avoids probate because two people or more own the asset together. And when one person dies, the survivor owns it. So, real estate, checking account, motor vehicle, aircraft, Charles Schwab or an E-Trade or a brokerage account, mutual fund, what am I forgetting? Cars, RVs, planes, trains, automobiles, all that stuff, right? So I could add, this is really common, so maybe for example, I need my son to help me pay my bills as I get older. So I will add my son onto my checking account as a joint owner with survivorship. So now I go down to the bank, fill out the forms of the bank, and add him to my checking account so he can pay bills, write checks, make deposits, all that kind of stuff as a joint owner. Then if I die, he notifies the bank that I died, gives him a death certificate, and now he's on the account automatically. It's his. So that's one way to avoid probate because it just transfers over to him automatically. Really common, people do that all the time. Just so you know, there's a downside to that. Number one, if my son decides to basically take all the money out of the account, maybe he's over at the casino and needs money or something, joint owner, they can take all the money out because they're a co-owner on the account. Their problem with it is theoretically, I say theoretically because I've only seen this happen like one or two times. If he got into a car wreck or something and got sued and didn't have enough insurance, they could go garnish that account because he's a co-owner on that account. Or if there's a tax lien or something like that. But very common, see that quite often. There are problems you run into with that, just so you know. I've had this a few times where if I had multiple children, I only have one person on the account, my son for example. I die, he gets all that money. He may not share it with his siblings. And the question is legally, does he have to? And that may not be the case. So there are some downsides to it. The next one is similar, but doesn't occur until after death. So this is called a POD or a TOD, a POD or a TOD. Page 108. Pay on death designation. So again, a bank account. We now have these available on real estate for deeds called a transfer on death deed. So I can add people's name as post-death owner. And the idea here is I fill a form out, let's say with the bank. I use Charles Schwab to trade stocks and whatnot, so I have this in my Charles Schwab account. I have a POD form where I've named my 3 children as the pay on death beneficiaries. So that's a form I fill out, I give it to the brokerage or the bank, and it says when I die, transfer this account equally to my 3 children, POD. Or a checking account, or a money market, or real estate, like I said. So they don't own it or have any right to do anything with it until I die. That's the difference. In the joint account, they're a co-owner. So, like if I want to sell, they're going to have to sign off on the paperwork to sell the asset. Here, I can change my mind as long as I'm alive and mentally competent. As soon as I die, they notify the company and it transfers over to them. Works very well. Number 3, also very common, is to designate a beneficiary through a beneficiary form. Life insurance, This says IRA, individual retirement account, 401k, which is another form of a retirement account. You guys don't need to worry about those specifics. But basically, this is a form you fill out for life insurance or retirement accounts where you designate who you want to receive the money from the life insurance policy or to take over your retirement account after you die. So like in my case, I have my wife designated first as primary beneficiary, and my 3 children as contingent beneficiaries. So if she dies and I don't update the form, it will automatically go to my kids. Really common, and again, it avoids probate. Why? We don't have to go to court. It's done through the life insurance company, through the IRA company, through the 401k company, or whatever. All right, number 4, a trust. A trust is becoming a very common and popular way to do estate planning for various reasons. One is for estate tax purposes. There are ways to plan for estate taxes. Trusts are also used for special needs, children or whatever, so you can set up a lifetime trust for their care. And then also, they avoid probate. They work as a tool to not have to go to court. So what is a trust? Now, trust can get very detailed and technical, way beyond the scope of this class. I just want to, in general, tell you the basics behind how a trust works, sort of in plain English. And the reason why is a lot of you will set up trusts someday. They're really common, do quite a bit of them nowadays. So just the basics of a trust. So page 113. So, here's the basic idea behind a trust. A trust is a piece of paper. Literally a piece of paper that has legal existence. It's called a juridical entity. That is an entity by law, a paper person, so to speak. So in law, we have a number of these type of fictitious paper entities. We have corporations, S corps and C corps. We have LLCs. We have nonprofits, 501c3s, C4s, C5s, C6s. We have unions. We have charitable organizations. We have governmental entities. We have churches and other type of religious entities. So these are not, human entities. We're all human entities. They're legal entities. So a trust is the same thing. It's a legal entity. So I could literally write a trust right now. I, John Hasbrook, hereby create the John Hasbrook Trust. I hereby transfer ownership of my house, my bank account, my gold, all my sporting equipment, everything I own into my trust. I will then deed and transfer title and my house over to the trust. And I will be the trustee, the person in charge of the trust, so long as I'm alive and mentally competent. If I become mentally incompetent or I die, my brother Bill Hasbrook will take over as the new trustee. And then, after I die, my brother will distribute the assets down to my 3 children equally as the beneficiaries. So basically, the trust is kind of like a ship, right? This is a ship. So this is the good ship trust. And we have a captain of the ship here. Here's our captain with the steering wheel. Steering the ship. Got to have a cool captain's hat, right? The captain of the ship is the trustee. Now the ship has to have cargo, right? So I put the cargo into the ship, and my house, and money, and whatever I own, motor vehicles, whatever. So the cargo is in the trust. The trust is captained by the trustee. I am the captain of my ship as long as I'm alive and mentally competent. If I die, I name a new captain, a new trustee to take over. That'll be my brother, or my brother-in-law after him if he's not around, or eventually it'll be my son if he's at least age 30. So the trustee is like the captain of the ship. Now, the whole point of a trust is I am the one that sets up the trust. I would be called either the trustor or the settlor. I take the assets that I own as a human and I transfer them over to my trust, and my trustee's in charge. And then the trust document, the paper will say after I die, distribute the assets down to my kids, or to my wife, or wherever I say, right? Now that avoids probate. Why? Don't have to go to court. Why? I don't own the asset. I died. My trust owns the asset. My trust doesn't die. It's a paper person, corporation. So that's the basic idea, okay? Now I'm not going to make you diagram that all out, okay? I just want you to have that basic concept because they are really common. They can get kind of confusing in a way, but ultimately that's the whole idea. You don't own the asset, your trust does. Okay. So back to page 5. Again, how to avoid the full-blown probate process, which can take months and months and months and is very expensive. An alternative to full probate is what's called a small estate. This is kind of like small claims court for probate. Very common, we do a lot of these. And this basically is where you file a small estate affidavit. An affidavit means a sworn written document under oath that's notarized. So you're swearing that it's true. So in Oregon, we have a small estate affidavit. If you have less than $200,000 worth of real estate and or less than $200,000, excuse me, $75,000 of non-real estate, combined total $275,000, you can file a small estate, which is a one-time filing with the court. You file the will, copy of the death certificate, and then you can distribute the assets according to the will. Or if you don't have a will, you're intestate in accordance with Oregon law. Very popular, very common. Most states have them. Our dollar limits in Oregon are pretty high relative. Like other states are 10,000. And they're actually talking about raising that limit. I kind of hope they do, because it's pretty handy not to have to go through a full probate. All right, number 6, DMV, Motor Vehicles Division. Same idea, an affidavit, a sworn statement, where you say this person's died, the only asset is a car, and that needs to be transferred through their will to their heirs, or if they don't have a will, intestate. And you file that with the Motor Vehicles Division, and you can transfer title. Number 7, again, how to avoid probate. Give it away while you're alive. That way when you die, you don't own it anymore. Right? It sounds like a joke. It's true. Very, very true. Now, again, I tell this to people, especially if they have a lot of antiques and whatnot they don't really use anymore, and they want to go to specific people, go ahead and give it to them now. Make a list of it so we know that you did that, so there's not going to be a dispute later. But if you're not using it, you want them to have it, go ahead and give it to them. And that way, too, they can ask you about the history of it or things like that. Now, the other technique here involves estate taxes. I just had this case this morning, actually. So, remember, $1 million for Oregon estate tax, right? So I had, let's say we have Grandma comes in, Grandma Oma. All right? And she's worth $1.1 million. $1.1 million. And, she's, let's say in her mid-90s, healthy for the most part, mentally competent and everything. But she's concerned, okay, if I die, there's $100,000 there that's going to be subject to tax, or $10,000 of Oregon tax. So she can give away $15,000 per person per year without there being any tax implications at all. You don't have to report it. It's not income. Whoever receives it can get it tax-free. So she's got $100,000 there she has to get rid of. And so she gives $15,000, let's say she has 4 kids, 15, 15, 15. They're all married, so 15 to each of their spouses. $120,000 altogether, right? So she just gave away $120,000. So when she dies, she's now at $980,000, which is below the $1 million filing limit. Don't even have to file an estate tax return anymore, just save 10 grand by giving away money. Now, I know it seems kind of weird. Now, you've got to have enough money to be able to live on, and she does. She's got very low expenses. So basically, that's what she's doing. She's going to go cut a check. And she's not going to write a check for the exact 15. She's going to write it for like $14,627 or something. The reason why is your $15,000 is cumulative for the year. So if I give you a birthday present, or I take you out to dinner, and I wrote a check for $15,000, we just went over the gift amount. So you don't want to do the exact amount, right? So you're audited. But that's a real world planning technique that you see if you're over the taxable limit. All right, filing number 8. This is a joke, but it's true. Be broke, own nothing, and then you don't have to worry about probate because you don't have anything, right? That's why they make cruise ships and RVs. You guys seen that bumper sticker? I'm spending my kids' inheritance. It's on the back. I don't have it there yet. I'm going to put that in the back of my RV, right? While I go tool around the country. All right. 100% for sure. What are different ways to avoid probate? This is probably the most real-world page that you've looked at all term.
List 4.
Say what?
List 4?
4, correct. List 4. All right. So back to reasons for estate planning. I'm going to go through the rest of these fairly quickly. Number 6, avoid a give. Oh, question over here, yeah.
What if I have 900,000 in my bank account and the rest I have it out of the country? That wouldn't count, right?
Okay, that's a great question. So in Oregon, this million includes assets outside the state of Oregon.
No, out of the country.
Yeah, it doesn't matter.
Okay.
And so if you die in Oregon, they're not taxable per se, but if they bring you over that $1 million level, then you have to report in Oregon if you're in Oregon. And so, like, I'll give you an example. Probably a better example would be, I have a client that has property in Oregon, which is worth about $800,000. And they have property in California, which is worth about $2 million in California. Now, California does not have an estate tax. But combined, they're $2.8 million. So what happens, Oregon will require them to file an estate tax return, and they'll have to pay tax on the ratio of Oregon property versus out of Oregon property. And it gets very complex. So your question is, now if it's out of the country, I don't know if that still falls within Oregon's jurisdiction or not. I've not had that occur before. But if it's within the United States, if it puts you over that $1 million level and you die here, then you have to file. Yeah. And it can get there's a ratio, a math equation, prorated. All right, number 6. Avoid a gift to a relative. Now what I mean there is if you, under Oregon, intestate law, if you don't want somebody to inherit an asset, you want to make sure that you specifically state that. Otherwise, they might be able to make a claim against your estate. Or if you die intestate, then they would automatically have a right. So, for example, let's say I had this case here a while back where the mother had 3 children. One of them is in prison for murder, life sentence in Colorado. She's here in Oregon, so she doesn't want her son, who's in prison, to inherit anything, obviously, because they're in prison. She wants to go to her other 2 children. So, what do you got to do? You've got to make out a will, because otherwise, intestate, her children were divided equal. So the prisoner's share would basically get taken by the state. So that kind of thing. Or maybe you've got a situation where you don't want a child, or you're estranged or whatever, so you got to make sure you address that through a will or a trust or some other document. Number 7, after divorce or marriage, you need to do a new will, Divorce or marriage has the effect of revoking a previous will, and so you need to do a new one, or reaffirm the old one, depending. Number 8, if you have final wishes, you want to be cremated, you want to have a big party, you want to do whatever, you want to put that in your will, and that way it'll be part of the estate. So for example, I had a lady I wrote a will once for. She wants to be cremated, and she wants to have her ashes put into a tarn. You know what a tarn is? I didn't know, I had to look it up. Anyone? Bueller? What would be your guess? I thought it was like an urn or a vase or something. A tarn is a high mountain lake that's created from glacial meltwater. She didn't know that, right? So I had to look that up. So she wants to have her ashes put into a lake up in the mountains. Now she's still alive, as far as I know, so it hasn't occurred yet. Kind of reminds me of that movie, it's the Lebowski movie, right, where they're spreading the ashes. You guys know the scene? You ever seen Great Lebowski? Never mind. All right, that won't be on the test. Healthcare instructions and mental incapacity. So planning, if you become incapacitated due to disease or injury, you want to plan for that ahead of time. I've talked about that a little bit, but primarily the document you're going to want. Some states call it a living will. In Oregon, we call it an advance directive. And this is where you designate a person, multiple people in order to be your healthcare representative. That way the doctors know who to talk to. You also can make decisions if you want to have tube feeding, if you want to have life support, yes or no, or as your doctor recommends, and other kinds of decisions involving end of life. Power of attorney is a form where you designate someone to be your representative for financial purposes. And this can be all-encompassing, which we call a general power of attorney, or very limited, called special power. And that way, if you get sick and you can't do things on your own, they can write, pay your bills, do your taxes, access your documents and records. If necessary, sell your property to pay for your care, that kind of thing. And hopefully you can avoid having to go to court for what's called a guardian or a conservatorship, which I won't get into in this class, it's too complex. Finally, number 11, benefits planning. What I'm referring to there is way beyond the course of this, but basically planning for public benefits like Medicaid for nursing home, VA benefits if you're a veteran, other type of public benefits if you have disability. The idea there is if you have, if I have a child that's disabled and they inherit a bunch of money in their name, they'll lose their eligibility for public benefit programs. And so we need to have what's called a supplemental needs trust, which is a trust that holds it for them instead of them getting it. It's very complex, but it is important that you set that up ahead of time. Now for you guys, again, for the final fill in the blank, what are six reasons for estate planning? I want you to know, what does intestate mean? Don't have a valid will. Probate, going to court after somebody dies. Those are the two main words there I want you to know.
Probate?
Probate, right here. Going to court after a person dies. That's what probate means, going to court. Okay, that takes us to page 114. My favorite page in the whole book. There isn't one, right? We're done. Okay. So let's talk about the final exam. There's a sign-in sheet. Are there a bunch of numbers on top of the sign-in sheet?
Yeah.
Yeah, well, that's where they live, okay. I don't know what I did with that. Oops. Okay, so the final exam is next week, which is what, March 21st, I want to, no, 20th? Yeah, 20th. So March 20th here, in our normal room here at 4:30. Same format as the midterm. You'll need a Scantron form, so make sure you bring the green computer form and a pencil. And all of your true, false, and multiple choice answers, just like the midterm, will go on it. And then we'll have fill in the blank questions. All of the fill in the blank questions come out of my blue book, all of them. So, let's go through what pages. So starting with page 66, for sure, 100%. What are the three elements of a contract? Offer, acceptance, consideration. Next page, that's fill in the blank question. Page 67, list 4, types of contracts. And I want you to know the difference between them, unilateral versus bilateral, express versus implied, executory versus executed. Page 68, which is part of that list, Uniform Commercial Code, sale of goods. Void contract, which is illegal, invalid, cannot be enforced, like a hit contract. Voidable, meaning it may be called off.
68,
67 and 68, okay?
both of them list 4,
List 4,
each page.
no, both pages. Okay, so then we have the page 75, list 4. Okay, and then I want you to know which one, these are examples of contracts that have to be in writing, remember? Otherwise, they're not enforceable. So any marriage contract, like a prenuptial agreement, any contract for more than a year, real estate, if you promise to pay a dead person's debt, sale of goods in the future, and then finally, if you're a co-signer on a loan, that has to be in writing. If it's not in writing, it's not enforceable. All right, next fill in the blank question is page 77. What are 4 ways that an offer for a contract can be terminated? And the 2 main ones, you say no to the offer, you reject it, that will terminate it. If you make a counter offer, that terminates it. Or if the person pulls the offer and cancels it, and they revoke the offer. So 4 ways that you can terminate an offer. Next is page 79. What are the 3 M rules? And I want you to know what those rules are. Meeting of the minds, that is, you have the same intent. Mirror image, that means the offer matches, the acceptance matches the offer identically. And mailbox, that is, the offer is accepted when you send the mail, when you hit send, when it's dispatched. Oh, I forgot. Sorry, page 74, under consideration, quid pro quo, that term there means this for that, this for that. It requires an exchange for there to be a contract. That's on page 74. All right, next for fill in the blank, page 80. What are 4 business forms? So the ones I have highlighted there. Sometimes I will ask it slightly differently. I'll ask which ones have limited liability. So list 4 that have limited liability. And again, you don't have to write them out. You can put LLC, LP, that's fine. Okay. Page 81. List 4 of the factors that you will analyze. And I have those all summarized again on page 82. So, list 4 of the businesses, organizations, top line, and what are 4 of the factors that you will analyze when you're deciding which one. which ones have limited liability, which ones do not, which ones have double tax, C Corp, which ones do not. All right, page 100 is the next one. Okay. List 4 estates in land.
I was skipping page A corp, the C corp, and
Thank you. Page 84. This will not be a fill in the blank. This is just know the difference between the two. Double tax, single tax. Unlimited number of shareholders for a C Corp, limited 100 shareholders for an S Corp. You don't need to know that number. So this is not a fill in the blank. So I'm not going to make you list out the differences, okay? Main thing is double tax, single tax. All right, so page 100, what are 4 estates and land? And then what are the ownership with survivorship and no survivorship that we talked about? Then we go to page 106, 100%. Requirements for a will, WSW with capacity. Page 107, 100%, 6 reasons for estate planning. And then finally 108, there are 4 ways to avoid probate. All right, so I wrote them all down here. If you want to take a picture of this, you can. Those are the list pages. Everybody see that okay? I apologize for my bad handwriting. Those are the pages that will be lists. That doesn't mean the other pages won't be in there, but they won't be lists. Okay. Extra credit. Extra credit is due the day of the final. So you're online. A lot of you have already done those, I've noticed. It's great. You've got till the day of the final to do those. Your grades will automatically go into Moodle. The short answer, if you want to do those, you can do all 15, you can do 2 or 3, whatever you want. Each one's worth 1 point, up to 15 points. Those you'll need to turn in the day of the final. So just bring them with you to the final exam. Please write your name on every page and make sure you staple them together. Question?
The short answer have to be handwritten or typed.
No, I want them handwritten, please. I don't care if you have bad handwriting. I have, as you can see, horrible handwriting. I don't grade you on your penmanship. I don't grade on spelling. The reason I make you do it in handwriting is that way I know people didn't cut and paste it, right? Simple as that. Other questions? So when's our final? Next week, 4:30. If for some reason you cannot take it that day, you could take it the day before at 8 in the morning. Nobody wants to do that. With my other class. If you want to do that, you need to send me an email so I can approve it. But, you know, most of you don't want to come in at 8 in the morning and take the final. I don't want to be there either. So, if you do have some other question, feel free to call me or email me, and we're pretty much done. See you guys next week.